Hello, my name is Kevin Snyder of Snyder Law, and I'm an estate planning and elder law planning attorney in Irvine, California, and I help families plan to protect what matters most to them, their loved ones and families, their legacy, and their dignity. And today I want to talk to you about a new law called the Secure Act. Many of you may have heard in the news a passage of this new tax law that impacts your retirement and the taxes towards your beneficiaries perhaps in the future. So for my purposes today, I just want to highlight what the Secure Act is, and we're going to be addressing some consequences and potential solutions in future videos. But today is just about what is the Secure Act, because I think if we start with that good foundation, then we can move forward in looking at how it's going to impact us, how it's going to impact our loved ones and beneficiaries, and so that we can know how to move forward from there. But if we don't have a general understanding of it, then it doesn't make sense. So we're going to start there. Today's foundation about Secure Act. So, Secure Act. What does it mean? What does it stand for? Obviously, it's an acronym. And I have to commit this to memory because it's a long word, it's a long phrase. It's the Setting Every Community Up for Retirement Enhancement Act. The Setting Every Community Up for Retirement and Enhancement Act. The Secure Act. So in the name, it suggests that there are some good things about this act, or there should be, and there are, and we're going to talk about that. There's definitely some downsides, at least as far as our beneficiaries are concerned, and we're going to want to talk about that as well. So the key provision of the Secure Act and what's been talked about out in the news a lot is a downside, and that is the ability to stretch out for a lifetime to our non-spousal beneficiaries. Our retirement accounts is no longer a possibility. What do I mean by that? What do I mean by the stretch out? Previously, before, a beneficiary could inherit a retirement from a qualified retirement account, such as an IRA, an individual retirement account, and choose to take it as an inherited retirement account and stretch out the required minimum distributions for an entire lifetime. So it was based on your beneficiary's lifetime expectancy. So they can take that account and make it exist based on their lifetime expectancy, and that meant there was a lot of tax benefits for that. That the principal could grow tax-free, tax-deferred, and that they didn't have to take out large sums every year, so they weren't taxed as much on their individual income tax side on what had to come out of those accounts. So in other words, you can pass along a retirement account to a younger beneficiary, and there was an opportunity for them to stretch out or lengthen the life of that retirement account for a lot longer than it would have existed had you stayed alive and had to keep taking out those required and minimum distributions. So that rule is gone. Beneficiaries can't do that anymore, and it has been supplanted with a 10-year rule, meaning that non-spousal beneficiaries that inherit a qualified retirement account will have to withdraw the principal within 10 years. We'll talk about some of the impact and some of the exceptions to that later on. But that is the main component that people are talking about, is the tax implications for beneficiaries now, because they're going to have to withdraw from the retirement accounts we're leaving to them within 10 years, that principal. There are some benefits to the new Secure Act, and those are, number one, it has raised the age from 70 and a half to 72 when required minimum distributions need to begin. That's your required beginning date. Your RBD has now been changed, so it's not the end of the year in which you turn 70 and a half, but it's by the end of the year of that you turn 72 that you're going to have to start withdrawing required and minimum distributions based on your life expectancy. So that buys you a little bit extra time for principal to grow tax deferred, and also prevents you from having to pay income tax on amounts that you're required to take out, because if you don't take them out, then there'll be a penalty, so you're definitely going to be taking out minimum distributions. And so that becomes a problem for some people, because they don't need that excess income, but yet they pay taxes on it, and they much rather leave it in the qualified retirement account and allow it to grow tax deferred. But they haven't been allowed to do that because they've aged into it. So now they just raised that age to 72. So that's a benefit. Another benefit is that you can still contribute past age 70 and a half to an IRA, and you weren't able to do that before if you were a retiree. Some non-retiree benefits that are significant and important. There is a $5,000 qualified birth or adoption distribution. That means you can withdraw penalty-free up to $5,000 if there's a new birth or adoption. If you're younger than 72 and there otherwise would have been a penalty for withdrawal, there's not going to be for up to $5,000. Of course, you still have to pay income tax on that $5,000. You can use a 529 plan to pay off student loan debt up to $10,000. Now that might seem like an insignificant amount in light of the cost of education today, but I guess anything is better than nothing. So you can use up to $10,000 to pay directly the cost, pay down a loan, a student loan, and that comes out penalty free as well. They adjusted the kiddie tax. Now previously in 2017 under the Tax Cuts and Jobs Act that was passed that year, it imposed a new level of kiddie tax, meaning that if you were a minor child, if you're underage and you earned income, then it was taxed at a certain level. What happened was, unfortunately, that the tax level was at the highest bracket. And so it was very expensive to be an underage child, a minor, and actually get some income. And this was problematic for children that were receiving inheritances from other family members that were generating income, or they were beneficiaries of a retirement plan from a parent or grandparent and they were still minors and they were receiving income. Or a grandparent has set up a special irrevocable trust for them and they were receiving income. This was problematic. This changed now moving forward. So the kiddie tax went back to its previous standard in that the child is going to be taxed at the parent's tax bracket, not at the highest tax bracket. Now, it might still be the highest tax bracket if that's the parent's tax bracket, but it provides for a lot of opportunities for there to be lesser tax. So the kiddie tax has not been repealed, just the old version of it has been repealed, and it's a new version that is more approachable. Some other things that were passed that were important as part of the Secure Act that would be a benefit. There's up to $100,000 disaster relief that you can use from your qualified retirement accounts to help with the disaster relief if you qualify for being subjected to a disaster in a disaster zone. This was passed in response to some of the major disasters that occurred over the last couple of years. If you're older and you have, or you just have a lot of medical expenses, then there's a reinstitution of the medical deduction that you can apply. Previously, under the Tax Cuts and Jobs Act, they were adjusting that deduction to be any unreimbursable medical expenses above 10% of your adjusted gross income, or AGI. Now they have said retroactively back to 2018 that's down to 7.5% of your adjusted gross income. This is significant because there are some people that fit within that gap that had they had expenses above 7.5 but not above 10, and they were going to have to they weren't able to use that deduction anymore. And then when it comes to charitable giving, you can still utilize up to $100,000 of your qualified retirement funds to go pay directly to a charity. So for those that lost out on the charitable deduction, if they itemized because the standard deduction doubled and now it doesn't make sense to itemize charitable deductions, there's other ways in which you can give money to charities tax-free, and that's one of them. So, and then if you're a small business, your employer, there's incentives for you to set up 401ks for your business and your employees because they've increased the tax deduction for your business in that regard. So that would be important to take a look at. So there's a lot of benefits on the tax side for people alive now that want to utilize their qualified retirement, or they want to get some additional tax deduction from it, or they're not retirement age yet, they're not receiving minimum distributions, but they want to access penalty-free the money in their qualified retirement accounts. There's a lot of good stuff in the Secure Act, but the most impactful one that's there that we have to be mindful of is the fact that beneficiaries are not going to be able to achieve the lifetime stretch that they had before, and they're going to have to withdraw principal within 10 years. So we're going to talk about that in future video about what really that impact means for your beneficiaries, why I said that it's a problem and a downside, and then also some solutions of how we can get around that. But hopefully that this video was important for you to understand better the Secure Act. If you like, I have a downloadable PDF that we'll make available as well that you can download just in a one-page, see some of the things that I talked about right here, so you can just get a better grasp of it. And then, of course, if you have any other questions about it, you're still confused about things, or want to know and sit down and talk more specifically about how the Secure Act is going to impact you personally or your beneficiaries, please let's have a conversation. Happy to do that. Please reach out to our office and connect so we can schedule a time to connect and have that conversation. Always happy to help and be a good resource. So hopefully this was valuable to you. Again, my name is Kevin Snyder of Snyder Law. I'm an estate planning and elder law planning attorney in Irvine, and I help families plan to protect what matters most to them, their loved ones, their legacy, and their dignity. And I look forward to talking to you soon, hopefully. Okay, take care.